Well, good morning, everyone. Thank you so much for having me. Thank you to Case Western. This is an incredibly well-organized symposium, and it's been such a pleasure to be here during difficult times. And I think there's quite a bit of courage to organize an event like this, and I'm grateful to be able to be in conversation with such amazing scholars, both sitting next to me and on panels later this afternoon. Your work has very much shaped my own and inspired not just my research, but the trajectory of my career as well. So I'm so grateful to be here. Today, I'll be examining whether disability is different in the context of higher ed DEI. And I'm going to focus in particular on whether students with disabilities receive or received support through DEI offices that was something more than just legal compliance with the reasonable accommodation mandate. And I'll talk about what that mandate is and how it functions in higher ed. So just to give you a little bit of an overview of what I'll be talking about today, I'll be locating disability in higher ed DEI, who works on such issues, where geographically on a college campus, what do they do? Then we'll step back and examine the creation of disability-focused staff and offices on college campuses. That will help us understand where we are today and how those offices have either remained the same or have evolved over time. I'll briefly talk about the legal obligations that are specific to disability and the treatment of students with disabilities in higher ed. And finally, I'll consider, in light of all of the above, how the current wave of anti-DEI sentiment, wave is putting it lightly, right, impacts disability potentially differently than it does other identities that were arguably supported by DEI offices. Okay, so let's try and locate disability in higher ed. Where exactly does it exist? Who, what, where? So the who, to the extent disability was or is still represented in DEI or elsewhere, the people generally had very specific titles, and some of them continue to have these titles. So we're looking at people who are the ADA coordinator or the Section 504 coordinator, people sometimes known as accommodations officers or resource officers. I'll talk about what those terms mean in a few slides. What were they doing? Well, for the most part, what they were doing is what they continue to do. These individuals that I just described are largely responsible for granting or denying reasonable accommodations requested by students with disabilities. In other words, ensuring compliance with federal law. Some types of people I described, accommodations officers or ADA Section 504 coordinators, are involved in programming like planning disability pride events. And given the presence of our Georgetown colleague, I have to give a shout out to Georgetown, which has a disability cultural center. What is unique about that particular program or office is that it functions independently from Georgetown's accommodations office. It's unfortunately quite rare for students with disabilities to have a space on campus that isn't devoted primarily to either the provision or denial of reasonable accommodations. So thank you, Georgetown. Another point to be made, to the extent there is a campus office labeled disability resources, it typically serves only students. That's true on my campus. And there generally isn't a similar office, a centralized place where employees with disabilities are able to find resources or perhaps even community. And then just thinking very literally, so where exactly is this disability-focused staff? Until recently, many of them existed in a physical DEI office. They might continue to exist in that space, although as we all know, especially on state school campuses, those offices are just disappearing. But disability-focused staff might also work in a student services office that has a unit dedicated exclusively to disability. So what about people with disabilities who are employees, so faculty or staff? Well, those people might have been in a DEI office. Those individuals often are located in a human resources office. And what's interesting, so on my campus, unfortunately, like many others, we just shuttered our DEI office. So what happened to the people working on disability? Well, the ones that were working on employee-focused resources. We can think of that either as a euphemism or not. They just got moved to human resources. Before there was a DEI office, the people that worked on accommodations for faculty and staff were in human resources. So we'll be thinking today about what exactly, again, did DEI mean for people with disabilities? Their titles haven't changed, the location of their office has changed, have their duties changed? I think we still need to figure that out. Okay, so a trend that I've noticed ever since DEI or DEIA offices began appearing on college campuses is that the services provided to people with disabilities under the DEI or DEIA umbrella often looked like an example that I pulled from Columbia School of Professional Studies website. That is, to the extent that the landing page represents the services or what that particular office is intended to provide, there'll be a description of what DEI represents on a particular campus, the resources provided to the communities that are served. But when you start looking for what accessibility means, you'll see that it is the sole component devoted to services for people with disabilities. And even in DEIA, DEI spaces, all that accessibility means, or all really that people with disabilities are provided with, is the ability to ask for a reasonable accommodation. So what exactly was happening for people with disabilities in these spaces? It's worth talking about a little bit more. Okay, so let's go back in time and think about the creation of disability-focused staff and offices in higher ed. So I've been studying and really enjoying the work of Andrew Lucchese and Jay Dolmage. Jay Dolmage wrote the book Academic Ableism. This portion of my presentation and paper is also inspired by Margaret Price's work and Linda Samuel's work about crib time, crib spaces. Andrew Lucchese wrote this fabulous paper looking at how there were disability services provided to veterans returning from World War II in the 1940s that expressly, meant to bring them back into a community, to give them the experience of college life, but also had this very intentional rehabilitation focus. So Lucchese he examined what was happening at the College of the City of New York, which was folded into what is now CUNY back in the 1940s. So there was this program designed for students who were recovering from military wounds, and it was highly medicalized. And in order to gain admission to this program as a veteran that was either in recovery or had permanent, what we would say now are disabilities, these students had to be subject to an examination by an entity known as the Health Guidance Board, a group of faculty, administrators, and physicians that would decide if they were injured enough to enter into the program. And then once these students arrived on campus, in addition to their regular curriculum, they had to satisfy the university's 2-year hygiene requirement through a special physical hygiene course. And then there was constant conversations between physicians and instructors. There was no confidentiality given to these disabled students' medical records. And so the way it was presented is we're all interested in the health of the student, but if you study disability law, you know that there are different models of disability. I can't think of a more medicalized version. They were literally trying to fix them and change them and rehabilitate them for whatever version of society might still be welcoming to them in the eyes of the program. So that sounds horrific, I hope, but unfortunately there are still remnants of that type of program in the way that we provide at least accommodations to students with disabilities in higher ed today. So for example, how do you get a reasonable accommodation as a student with disabilities in higher ed? You have to go to a doctor, at least one appointment. You have to fill out forms, you have to get medical documentation. Your medical records are going to your university, right? And then they're reviewed, they're scrutinized by the Disability Resources Office, who makes a determination about whether you are disabled enough to get, for example, extra time on a test. And the other aspect that always sort of bothers me but reminds me of how these systems started off in a very medicalized way. We require students with disabilities, we use the word register. You have to register for services. You have to put your name on a registry. I think we should all be a little uncomfortable with the idea of requiring a minoritized group to register and to start collecting a list of names based on identity. I've tried really hard to get my own university to drop the name registry, which suggests that as a disabled person you have to be somehow registered. And also we require people to re-register, right? You can't just do it one semester. You have to continuously certify that you are disabled enough. So I would contrast that to what was happening at Berkeley in the 1960s and 70s. So we generally focus the start of what became the independent living movement on the arrival of a person named Ed Roberts at Berkeley in 1962. Ed Roberts had polio, he had an iron lung, he fought to get admitted to UC Berkeley, and then where he was going to live became a real human rights issue and also a problem, right? Where can he reside? And so what Berkeley did was they retrofitted a floor of its campus hospital. Problematic, right? And that's where Roberts lived originally on his own, but then it became this space where other people with other students with disabilities also were assigned. So you had a very much segregated form of living for students with disabilities. But for anyone that's a person with disabilities in this room, especially a young person with disabilities, you know how rare it is to be able to find community. So these young people started to form bonds and to organize an incredibly active group of people. So although it was a segregated living experience, it was also this amazing place where a civil rights movement really took off. The people that lived in the facility, the dormitory that Roberts was in, became known as the Rolling Quads, and they pop up across all kinds of civil rights movements. The individuals that met at Berkeley in the 60s and 70s. If you watch the movie Crip Camp, you know that some of these young people met at a summer camp and then ended up going to Berkeley and participated in the infamous 504 sit-ins in the 70s. One little anecdote that I love, because it's student-driven, in 1970, students received a grant of $80,000 from the Department of Education to form what was known as the Physically Disabled Students Program. And it was much more resources-based. In fact, there was one person, an assistant director, and all he did was wheelchair maintenance, which sounds a little bit mechanical, I guess, or secondary. But oh my gosh, the way that we all need help with mobility aids, that's exactly the kind of resource that makes your quality of life excellent. So fast forward to today, there are many affinity groups that exist on college campuses that are meant to create community for students with disabilities in grad schools too. There's likely a Disabled Law Students Association here. But I myself have never run into anything, and I have to take responsibility myself too, anything that approximates the kind of community, the kind of student-led community and advocacy and resource center that existed in Berkeley in the 60s and 70s. I think the model, whatever we call resources on college campuses, is still very much medicalized. Okay, let's talk a little bit about the law. First, what is a reasonable accommodation? I've been using that term a lot. Mark Weber has said that the accommodation mandate built into the laws I'm about to talk about requires changes in the way things have always been done in order to permit people with disabilities to integrate into society on a plane equal to that of others. Could be receiving extra time on a test, could mean the removal of a physical barrier in a law school's courtroom if you can't get up steps, perhaps, and I'm being a little bit silly here, but courtrooms in law schools in general, are not very physically accessible spaces. It's hard for people with mobility impairments to navigate them. Again, in higher ed, permission to attend class virtually is a pretty classic form of accommodation, reasonable accommodation. So what laws are colleges and universities governed by? If they receive federal funding, the Rehabilitation Act of 1973 and Section 504 in particular. Terminology varies a little bit. Instead of reasonable accommodation, you might see the phrase academic adjustment or reasonable modification. There are wonderfully specific higher ed regulations implementing Section 504 of the Rehabilitation Act. What I love about them is that there's great detail about the treatment of students with disabilities in the context of student housing and financial aid and non-academic services. Title II of the ADA applies to state colleges and universities. Like the Rehab Act, Section 504, there's an accommodation mandate. In other words, you have to provide reasonable accommodations to students at Title II schools, subject to certain affirmative defenses. Private colleges and universities that are not religious institutions are governed by Title III of the ADA as public. Did I just say that? Public places of public accommodation. Private colleges and universities are places of public accommodation. So in any event, if you're not governed by the ADA, you're likely governed by Section 504 because of the receipt of federal funding. Disappearing federal enforcement, the Department of Education, which enforces Section 504, 7 of their 12 regional offices have been shuttered. The DOJ can investigate Title II and Title III violations. I don't think that is a goal of the DOJ right now, unfortunately. There was a robust history of Dear Colleague letters issued by the Department of Education's Office for Civil Rights resolving administrative complaints. There aren't that many lawsuits, there's not that much case law involving students with disabilities in higher ed, probably because that's not necessarily their, when you're a student, do you think about suing your school? Do you know that that's a possibility? Do you have the money to hire a lawyer? So the regs and the Office for Civil Rights was really creating what became precedent with regard to the application of these laws. So I'll just say that if we're thinking about resources versus accommodations, I've just explained that to provide a reasonable accommodation is to follow the law. It's not to provide a resource. So if we label an accommodations officer a resource officer, we're using a name that isn't exactly a great fit. Okay, finally getting to my point. Executive orders, how are they treating disability? So to back up a little bit and go beyond higher ed, there are 2 sets of regulations implementing sections of the Rehab Act that apply to federal employees and federal contractors and that require sort of I'd say a watered down version of affirmative action, but there is some form of affirmative action written into those regulations with respect to the hiring and treatment of people with disabilities in federal employment and federal contracting. And an interesting twist here, so there was a OPM memo from February 5th, 2025, and the titles of all these memos and exec orders, you know the tone. Further guidance regarding ending DEIA offices, programs, and initiatives. And then, so if you're taking action motivated by a protected characteristic, you can't do it anymore, right? But then there's a paragraph that says, well, of course, you still have to follow the Rehab Act, and you have to provide accommodations. And then a footnote was dropped to Section 501 of the Rehab Act as an example of a law that still must be followed. So what's going on with disability? I think there's confusion. I'm so sorry, I'm going to go just a little bit over my time to wrap up my thoughts here. Section 503, which... Okay, good, thank you. Then I'll slow down maybe. Section 503 is a regulation implementing the Rehab Act that requires federal contractors to try and hit a certain percentage of disability representation with respect to who they hire to work on the contracts they get from the federal government. And so this particular regulation, the regulations implementing Section 503 are under attack. There was a notice of proposed rulemaking issued in July by the Department of Labor that asked for comment regarding the affirmative action provisions implementing that particular section. There was a lot of feedback, a lot of comments, so the comment period got extended, I think until just a few days ago, but it looks like those provisions are under attack. What about staff titles and responsibilities? So going back to the higher ed context, because everyone was accommodations focused before and during the height of DEI, I don't think there's that much change with respect to responsibility, but if you wanted to go beyond just the legal responsibility, there's not much happening for anyone who's a member of a theoretically protected group. The impact on disability identified staff and DEI offices. So I have to say, from the perspective of a student with disability or a person with disability, we have a fraught relationship with the people that work as accommodations officers, because what we might perceive that person to be, fairly or unfairly, is the denier of a reasonable accommodation, right? And the denial of an accommodation can mean for a student with disabilities that you have to drop out of school. It's a really consequential event. So And I think it's fair to say there aren't a tremendous number of people with disabilities that work in accommodations or work as ADA coordinators or Section 504 coordinators. So what's the impact on people with disabilities to the extent that DEI offices are getting reconfigured or simply don't exist anymore? I don't know that there's that much. The Department of Education, in theory, is still enforcing disability law. I'm now going to do a quick comparison to other identities that were theoretically protected by DEI offices, just to show you the comparative difference. Okay, so if we're thinking about executive orders and actions, one example, this order from April labeled Reforming Accreditation to Strengthen Higher Education. Okay, thank you, yes. So what identities were called out? What were accreditors supposedly doing poorly? They were committed to diversity with respect to gender, race, and ethnicity. That was one of the ABA's sins. And these memos also mentioned Title VI of the Civil Rights Act, Title IX of the Education Amendments Act, not Section 504. So what is the target of what needs to be scaled back or eliminated are the laws that were previously relied upon to protect from discrimination on the basis of gender or race, and now those laws are being, I'd say, weaponized in a different way. If you look at the agreement that Columbia entered into with the federal government, it mentions race, gender, Students for Fair Admission doesn't mention disability. Staff titles and responsibility for the identities supporting people of color, for example, in DEI, DEIA offices. Those people's jobs are just eliminated, right? So what's happening? What's the impact on people that identify with the communities that they were serving in DEI offices? I think back to 2020, and we asked so much of people of color and women of color in particular, and they stood up and started working on these contentious and challenged programs that were under attack to focus on racial justice. There's an example from Stanford a couple years ago, Tyrion Steinbeck held a position that was DEI related. There was a confrontation with Judge Kyle Duncan. She ended up resigning, and I felt like there was just, what were we doing as a community to support her? I don't think we did enough. And then finally, what's happening with respect to the Department of Education and the Office of Civil Rights with respect to some of the other identities I just mentioned that aren't disability. There's, the instructions to that department, or at least the messaging coming out of that department, is that you're going to use Title IX, use Title VI, so gender and race, to ferret out what we would have just called non-discriminatory behavior a few years ago. Maybe we can call it reverse discrimination now, but the focus of that department is not on the problems that led to the passage of our civil rights laws. And finally, I'll just say that, of course, people with disabilities have intersecting identities. It's not a good, being a person with disabilities, you're not safe right now, but maybe a little bit cynically, we can look at what was happening in those spaces, or more realistically rather than cynically, what remains, and how do we want to treat people with disabilities on college campuses beyond the law. We can't just slap on the word resources and be done with it. Thank you so much, and I so look forward to my co-panelists' remarks.
Q&A for everyone? Or, oh, okay, cool.
Great. Good morning, everyone. I want to thank the Law Review and symposium organizers for inviting me to be here today. I want to thank my co-panelists for being in conversation with me. And I'm going to talk a little today about the impact and afterlife of SFFA as manifest in a rise in reverse discrimination lawsuits and challenges. I looked at the agenda and I was delighted to be on a panel with the term equal opportunity in it, because the understandings of equal opportunity are in flux, and this is a flux that SFFA helped usher in 2023. And that flux includes a spike in reverse discrimination suits, and that's really small. It seems so big at home. Sorry about that. A spike in reverse discrimination lawsuits, a steady co-optation of the language and framework of equal protection and anti-discrimination when discussing the experiences of white people in the United States, and an offensive by this presidential administration premised on the idea that it is white people and not people of color who are suffering racial injury. The fate of DEI programs then is really dependent on the rise of reverse discrimination claims, because the argument is that DEI programs are reverse discrimination programs. Now, reverse discrimination claims are not new. As early as Reconstruction, for example, responses to the idea of reparations for the formerly enslaved included arguments that to do so would be to harm whites in ways that were legally cognizable. Conservative discourse on reverse discrimination, moreover, emerged forcefully during the 1970s when white plaintiffs began to repeatedly allege that their racial identity was being used to deny them opportunities from which racial minorities were exclusively benefiting. What may be new, however, is the traction this sort of framing is now getting. From the Northwestern lawsuits regarding faculty hiring, to the Fearless Fund lawsuit regarding money's use to diversify the venture capital space, to the welcoming of Afrikaners from South Africa as political refugees to the United States, it is increasingly common to talk about reverse discrimination as if it were a significant phenomenon, and scholars who write in this area really have to engage this new normal. So in this space, I argue that it is really important to think about reverse discrimination claims as racial projects. And my definition of racial projects comes from scholars and co-authors Michael Omi and Howard Wynant. And they define racial projects as the process through which human identities and social structures are racially signified, and there are several ways that racial meaning becomes embedded in social structures. As they explain it, race manifests at the intersection of social structures and cultural representations. If we only think about race as structural or institutional, think laws, policies, organizations, then we miss what it means to give race meaning in the United States, right? It doesn't just operate in terms of material realities, there's symbolic meaning. But if we think about race purely as symbols, or think about it purely as cultural patterns, we miss the ways that structures and institutions make race real and give it material consequences. Racial projects then do both. They link the ideological and practical work of making and remaking our understanding of race in the United States. So racial projects can be laws, they can be social movements, they can be political initiatives, they can be cultural phenomenon. But whatever form it takes, it interprets and explains race to us. And then, based on that meaning, we organize and distribute resources along our new understandings of race. Racial projects can happen at the state level, the institutional level, the micro level, the individual level. Now, racial projects can be good or bad, and assessment is not linked to the race of the group advancing a particular project, or even what the project's stated goal is. According to Omi and Wynant, what makes a racial project racist is if it creates or reproduces structures of domination based on essentialist categories of race. We might then consider a conservative Black racial project, one opposed to race consciousness because it purportedly fosters dependency on the state. And that project might be spurred by Black people. But it doesn't mean that the goals of such a project don't reproduce structures of domination, right? And so looking at just the identity of the group advancing the project isn't sufficient. We might look at a Latino racial project that is invested in the Republican Party as led by Donald Trump. And as headed by Donald Trump, the Republican Party has been engaging in a lot of demeaning rhetoric about Latinos, including suggestions, if you remember, that like Puerto Rico is an island of trash in the Atlantic, right? It's really demeaning language about people from Latin American countries or Spanish-speaking countries. And yet, during the same decade that Trump became the face of the party, Latino support for the party grew from 29% in 2012 to 39% in 2024. Right, so how do we assess a Latino racial project that is potentially increasingly invested in the sort of racial ordering and reordering that the Republican Party, as led by Trump is advancing? Racial projects also borrow from and against each other, sometimes making complementary claims about race and sometimes making competing claims about race and racial hierarchy. So while minoritized racial projects are typically thought to be developed in response to racial projects that advance white supremacy, minoritized racial projects also speak to each other in attempts to flatten racial hierarchy or even climb racial hierarchy. In this context, we might think about the inclusion of Asian plaintiffs in SFFA suit. Right, Asian plaintiffs were particularly useful in SFFA because the model minority myth under which Asians have to labor made them a more sympathetic plaintiff than people like Abigail Fisher. And two, the model minority stereotypes made for useful comparisons to other minority groups, right? So we had hardworking, test-acing Asians versus lazy, welfare cheating Blacks and Latinos, right? Who weren't doing well on the tests, but were still getting these benefits. In this sense, an Asian racial project advancing a sort of reverse discrimination claim both sort of corrals the language of traditional civil rights rhetoric while also trading on other racial projects that have sought to justify the location of Blacks and Latinos at the bottom of a racial hierarchy in the United States. So if that's how we understand racial projects, then I would argue that SFFA, the suit and the movement behind it, and other reverse discrimination challenges are racial projects. SFFA as a racial reverse discrimination suit was about institutions and material realities, right? So I tell you the racial projects are about symbols and patterns. They're also about institutions and material realities. So as a material reality, higher education is a valuable good, and elite education even more so. We know post-secondary education is associated with lower rates of unemployment, higher income for all racial and ethnic groups. It serves as a signaling function to employers and imparts cultural and social capital that people can use to navigate life's ups and downs. Race-conscious admissions was an attempt to try and broaden access of minority groups to this valuable resource, an attempt to extend the distribution of the resources of elite education in particular to people of color. The ultimately successful challenge to SSFA then was an attempt to redirect these resources back to white people along racial lines, right? So we are redistributing this resource according to a new meaning of race, which is framed by the idea that race-conscious admissions is discrimination. SFFA, however, was also about racial meaning, also about symbols. The rhetoric that accompanied the lawsuit and other reverse discrimination claims is always the same. We have to advance colorblindness, right? If you consider race for both benign and invidious sources is a constitutional violation. It does not matter what the goal is. To consider race anytime demeans individuals on a level that is similar to racial discrimination that was leveled against minorities in the first instance. The consideration of race is always divisive, always unnecessary, always punishes innocent whites, always rewards undeserving minorities. And in that sense, SFFA is advancing a particular narrative, a particular meaning about how race does and does not matter in the United States. According to the petitioners in the case, today's understanding of race cannot be informed by yesterday's understanding of race. According to the petitioners, the disproportionate representation of whites in elite higher education is a natural and neutral baseline, uninformed by centuries of racial subordination that has benefited whites and harmed people of color. So SFFA and the other reverse discrimination suits that are currently percolating are a racial project, maybe we might call it a white racial project, attempting to maintain racial hierarchy or reestablish a hierarchy that was being threatened by the advance of race-conscious admissions. In closing, I want to talk about the value of thinking about these movements as racial projects, right? We could describe them in this way, but so what? What does it help us do, right? Why might it be useful to think about it in this way? And I think first that thinking about these projects as racial projects and really political projects reveals that doctrine may not actually be very helpful to us, right? We might think about adjudication itself as a form of racial project. Despite the calls of equality scholars for an anti-subordination approach to anti-discrimination that obligates the state to affirmatively dismantle racial hierarchy, the court has instead insisted on an anti-classification approach to equal protection. As a result, the court has subject both benign and invidious uses of race to the same level of judicial scrutiny. It does not matter if it's helping or hurting, it's still going to be subject to the same analysis. Under such a regime, facially neutral laws with a disparate impact on racial minorities are preserved, as long as explicit discriminatory intent cannot be found, while race-conscious policies intended to address racial inequality, like the consideration of race admissions, are prohibited. So we're getting sort of race and remedy exactly backwards, right? If it has an impact on a group that hurts them, as long as you cannot find formal language, it's fine. A policy that's more forward about thinking about impact is going to be struck down. Adhering to an anti-classification approach that permits for reverse discrimination claims advances a racial project that maintains white supremacy, both symbolically and materially, while countering projects that are meant to dismantle racial hierarchy. Ultimately, then, we might think about the Supreme Court as functioning as a handmaiden to a racial project of reverse discrimination, even as it has acknowledged in other contexts that reverse discrimination claims are not always legitimate based on who brings them. And so here I'm thinking about Dynamics Land System v. Klein, for example, where the court heard a challenge to a collective bargaining agreement between General Dynamics and United Auto Workers that eliminated the company's obligations to provide health benefits to retired employees, with the exception of then current workers who were at least 50 years old. It was a statutory challenge, and so the court was grappling with what the statute read. But in a 6-3 opinion rebuffing the challenges, the court highlighted the historical disadvantage to older individuals, the widespread discrimination leveled against older workers, the cost that prompt employers to prefer younger workers over older workers, and the lack of legitimate complaints regarding discrimination in favor of older workers over younger ones. So we had younger workers who were saying, hey, this is discriminatory, right? We're going to get our benefits later, but your older employees are not going to. And the court said, oh no, you can't bring a suit, right? And because we actually don't understand that there's discrimination against you, right? People prefer younger workers. You're not going to get fired as easily. We don't have legitimate complaints, and so someone can bring a suit, but it's not young people because there's actually no structure of discrimination targeted at you, right? And so the court knows how to do this, right? And you could take these arguments and think about race, right? Oh no, you can't bring a reverse discrimination suit. We do not have data that suggests a pattern of discrimination. We know employers are going to prefer white employees based on what our cultural and racial patterns are in the United States, right? So someone can challenge it, but not you. But the court has chosen not to. Right? And so the court knows how to properly analyze reverse discrimination claims, to think about when they might be legitimate, but just refuses to do so in the context of race based on a particular racial project. Right? So what does that say about the court as a space where we might get equality, right? Doctrine and adjudication might not do it for us, and thinking about these things as racial projects might make that more obvious. Second, if we acknowledge that these are projects that construct meaning, right? Part of what is going on here is we're trying to challenge and shape people's understandings of how to think about race, then we might think more intentionally about the limits of litigation and maybe even the promise of the political arena. Litigation responses to reverse discrimination might themselves be thought of as political in nature. That is, litigation is not fought to win, but it is fought to create a counter-record that exposes the racial meanings and resource distributions implicit in reverse discrimination claims. A lawsuit challenging attempts to diversity faculty demographics through race-conscious hiring is only a new and unwarranted use of race if one ignores the public and private action that work to keep faculties historically white, right? So if we bring a lawsuit and say, oh, you've been thinking about race, this is a problem, it can only be a problem if we ignore why faculties are white, so white in the first place, right? And so discovery through litigation then can be useful forum to expose those uninterrogated racial baselines. You were saying how the faculty is composed now is neutral, but in fact, it is a function of how hiring is done, preferences, networks that are used that have tilted the faculty in a particular direction. And thinking about this in the context of SFFA, for example, that litigation exposed just how much of a benefit to white people the athletics and legacy admissions provided in the admissions context. Right? People were so horrified about this that we had a conversation about abolishing legacy admissions. Right? It became, well, if we really cared about racial equality, then we wouldn't allow athletes to get in so easily. We wouldn't allow legacies to get in so easily because we see that it's benefiting white people primarily. And so that started to change our understanding about race. In the case of faculty hiring, everything from access to developed alumni networks, spousal hiring, sometimes the creation of fellowships that allow people to bring spouses with them, legacy enrollment at elite institutions that facilitate later employment. All of that is grounded in de jure state action that ultimately develops into informal advantages and disproportionately advantaged whites. And we say this is sort of natural and occurring, but actually it's a function of formal processes. So wider exposure through discovery of this reality, even if not ultimately successful in winning or staving off the challenge, might be useful to us if we start thinking about these spaces as racial projects. Finally, if we can see that the court is advancing a white racial project, then perhaps the political process is a better alternative to resolving the competing claims to resources and racial meetings that various groups are making. Legislative processes, for example, might be superior because of the nature of racial projects. There are many ways to respond to inequality, and racial projects are neither right or wrong, good or bad. The only litmus test is whether it reifies racial essentialism hierarchy. And in this new political climate, the very nature of racial hierarchy is subject to debate. So although constitutionally prohibited according to the court, which I concede, why can't the United States think about racial quotas that other countries have used with varying levels of success? These are questions that require honest assessment of the benefits and costs of initiatives. The legislative process, with its capacity for democratic representation, data collection, opinion gathering, and ultimately negotiation, might be better suited to facilitate racial projects. And so I'm suggesting we are engaging in these projects, and what we need is transparent processes to say, yes, you're going to be disadvantaged because we're working towards this goal, right? This is a group that's going to be harmed, or what is discrimination? Do we have empirical data about that? And that might not happen very well in a judicial context. Hiding behind doctrine, right, however, and refusing to acknowledge the reality of racial projects, we are unable to honestly confront and answer these moral, social, and empirical questions. Just as legislative processes allow for disparate impact under Title VII, even as disparate impact goes unacknowledged at the constitutional level, legislative processes might produce the parameters for the engagement of race in public and private settings. If the state has the ultimate obligation to address discrimination, then perhaps race-conscious initiatives could be permitted at state institutions, right, but not private institutions, right? But these are debates that we can't have because we're like, doctrine tells us exactly what to do, and we can't actually talk about what this actually means, trade-offs to benefits. Maybe, given the expressive concerns animating notions of liberty and speech, private institutions like Costco can consider race, right, as long as that consideration is animated by a goal of remediation or diversity. But maybe state institutions are limited or prohibited in their capacity to think about race. In yet another iteration, the state, though limited in its consideration of race, might provide market incentives and encourage private institutions to consider race in their practices, right? All variations that we might consider if we were honest that what we are doing is trading racial projects, right? And people are winning and losing based on those projects. That's not a bad thing. That's just what we're doing. So what's the best forum for engaging that discussion? These bargains, however, cannot be struck until racial projects are acknowledged and their engagement is no longer limited just to judicial review that purports to be colorblind, but in fact just freezes racial hierarchies in place. With that, I'll stop and I look forward to your comments and questions afterwards. Thank you.
Is William Trainer going after me?
I think he's somewhat now.
Professor, are we going to the Zoom now?
Yes.
Thanks very much. Can you hear me?
Yes.
Very good. Well, I have to say, I'm sorry that I
Not
can't be
seeing
there
it.
in person. I want to thank Case Western and the law review and my co-panelists. I'm delighted to be part of this conversation. This is a time in what we're seeing in so many areas is the administration is really trying to stop kind of other voices that can criticize it. So we're seeing that with respect to mass media and what's happened to Jimmy Kimmel, for example. We're seeing it against law firms, where law firms are essentially being attacked because of who they represent and the lawyers that they have. And we're seeing it with respect to universities. Both Columbia and Harvard, for example, are being challenged with respect to their control of their curriculum. And Columbia has, according to the White House, agreed to essentially having its curriculum monitored for range of viewpoints, and Harvard is being challenged. And it really is something very fundamental. It's that, in a democracy, it's important that institutions have voices and be able to challenge government and the government not control what they say. That's, I think that's the larger issue that we're looking at. And what I'd like to focus on in my time is kind of what's happened at Georgetown and the way in which I responded. So, earlier in the spring, I was dean at Georgetown Law, and I received a letter from Ed Martin, who was the interim U.S. attorney, and he said, and I'm going to quote from him, "It's come to my attention reliably that Georgetown Law continues to teach and promote DEI. This is unacceptable. I've begun an inquiry into this and would welcome your response to the following questions. First, have you eliminated all DEI from your school and its curriculum? And second, if DEI is found in your courses or teaching in any way, will you move swiftly to remove it?" And then he continued, "You should know that no applicant for our fellows program, our summer internship, or employment in our office who is a student or affiliated with a law school or university that continues to teach and utilize DEI will be considered." So, what the interim U.S. attorney was saying to us was, that he had to, he would decide what we taught. And if our curriculum didn't pass muster with him, if we were, in his view, teaching DEI, he would punish our students and he would punish our graduates. And I have to say, when I got the letter, my initial reaction was that this had to be a hoax, because I couldn't believe that a federal prosecutor would send a letter like this and would be challenging a law school's ability to decide what it teaches. So my first reaction was it was a hoax, and I actually talked to our counsel's office and I said, what do we do with this? I think this is somebody is perpetrating a hoax against us, because this can't be something that a federal prosecutor would say. And they convinced me that in fact this was legitimate. It was in fact something that had come from interim U.S. attorney Ed Martin. And and then the question was how we responded, how I responded as the dean of the law school. And first of all, this was obviously very serious. It was a challenge to our ability to decide what we teach. It was clearly unconstitutional. But this is also a time in which, any decision like this to challenge the administration, is something that you have to, you don't do lightly. And, particularly when you're dealing with somebody with the power of a federal prosecutor. And, with an administration that we've seen in so many areas is vindictive. So, to challenge the administration is not something you do lightly. I talked to actually my wife, because this is and I said, this is something that, that they're doing that's clearly unconstitutional, and it's important that we fight back. But I want to talk to you about it because I think there's also personal risk that's involved in fighting back, and it's something that could affect not just me but all of us, the entire family. And she said you should do what's right. What I did was, I responded to the interim U.S. attorney that what he was doing was unconscionable. unconstitutional, and we would not comply with his demand. And so I wrote a letter to him in response, and I said, it's a Catholic and Jesuit institution. Georgetown is a Catholic and Jesuit institution. We're founded on the principle that serious and sustained discourse among people of different faiths, cultures, and beliefs promotes intellectual, ethical, and spiritual understanding, and that this principle is an educational and moral imperative. And that his letter challenges our ability to define our mission as an educational institution. It inquires about Georgetown Law's curriculum and classroom teaching, asks whether DEI is part of our curriculum, and asserts that you will not hire our graduates, individuals from our school, if you find our curriculum unacceptable. And that's flatly unconstitutional. That the First Amendment guarantees that the government cannot direct what Georgetown's faculty teach and how to teach it. And the Supreme Court has continually affirmed that the freedom central to a university's First Amendment rights are its ability to determine on academic grounds who may teach and what to teach. So that that was our response, and I also talked about kind of in addition to the First Amendment right that universities have, and the Supreme Court case law is clear that institutions have First Amendment rights. So there was the NRA decision from 2 years ago. That was the basic principle, that the NRA has First Amendment rights. And that applies to universities, and that is longstanding. It goes back to Justice Frankfurt's decision in Sweezy versus New Hampshire, which is 60 years ago. It's been reaffirmed by the Supreme Court. And it's really, it's a vital principle in a democracy, that universities should be able to teach what their mission directs that they teach. And I also talked about how, we're a religious institution, we're a religious and Catholic institution, that listening to all the voices, empowering everyone, is part of our mission. That kind of educational discourse among people from different backgrounds and perspectives is part of our mission. And so what he was doing in challenging that was not just challenging free speech rights, but was also challenging religious freedom. And so again, I think the Supreme Court, the School of Guadalupe decision stands for the proposition that religious schools can decide how they operate, what their pedagogy is, based on their mission. So it was a challenge both to the university's free speech rights and to a religious institution's religious freedom, and it was very direct, and that we would not comply. So that I would get a response, that would range across the spectrum. That some people would be supportive, and that other people would be critical of what we were doing. And I have to say, what I was really struck by was, the fact that I received kind of uniform support. I received actually a petition from 18,000 people, 18,000, who said that, identifying as Christians, they were writing to express support for what I'd done. And I have to say, I was just, when I got the petition, I was just astonished that 18,000 people from literally around the world had signed this petition. And I received support really from our most conservative alumni. Again, kind of the people who I was most hesitant about, how they would react. And it was just, kind of uniform support, again, from people across the spectrum, and literally around the world. So that was heartening. Now the one thing that I often say about this is, the one thing that I had kind of mixed reactions is when I read I read my draft letter to my wife Allison. I said, this is what I want to send. you have any comments? And she said, it's very good, and I really like it, and you should send it, but you should call him interim U.S. attorney. You should call him interim U.S. attorney, and you should do it several times. So the one thing that frankly mixed reactions is what I hear again and again is people say to me, that was a very powerful letter. We totally agree with you. And what I really like is the way you call him interim U.S. attorney. So that's all credit to Allison, and I want to acknowledge that, but I'd also like recognition of my contributions to the letter as well. I think, one of the takeaways for me for this though is, at a time in which, what we're seeing is really an attack on, people's ability to, other institutions' ability to kind of criticize the administration and to have their own voices. The uniform positive response is something that I really want to emphasize because it's striking. I mean, I've been between Fordham and Georgetown. I was dean of 2 law schools for 23 years. And I've done a lot of things that are controversial, and I'm used to receiving positives and negatives. I've never done anything like this in which the responses I've received have been, uniformly positive. And I think that reflects the fact that, we as a society realize that this isn't something that's important to fight over. And that it's important that universities have their voice, that law firms have their voice, that media have their voice. And, this is a time, again, in which we're seeing, challenges, in so many ways to kind of crucial players in civil society, ability to use their voice. And it's also striking to me, the hesitancy that some people have about speaking out and speaking back. There was a letter that law school deans, sent, kind of telling the administration that they were violating the Constitution and attacking law firms because of who they represented and because of the lawyers they employed. That was an attack on kind of the right to counsel that's a fundamental protection of the Bill of Rights. And what I was surprised was, first of all, it was just kind of a very vanilla letter, frankly. It was just kind of straightforward and struck me as kind of uncontroversial. And it struck me how hard it was to get people to sign. That there are 200 law schools across the country, and I think we got about 60 law school deans to sign. And I talked to a lot of people about why they didn't sign. There were a range of reasons. But I think this is a point in which the stakes are so high, and it's absolutely essential to speak out and to push back and to fight. And what we're seeing right now is, I think so many institutions are trying to, where the stakes are so high and the threat are so real, trying to figure out, where they draw the line, and where they fight back. And I think one of the areas that for me that's absolutely crucial to fight back on, is on, for universities, their ability to control, what they teach. That, for example, is one of the challenges with Harvard. So the letter that the Harvard president received says, and I'm quoting, by August 2025, universities shall commission an external party which shall satisfy the federal government as to its competence and good faith to audit the student body, faculty, staff, and leadership for viewpoint diversity, such that each department, field, or teaching unit must be individually viewpoint diverse. So kind of the attack that we had on diversity, equity, and inclusion at the Law Center is part of a larger challenge that we're seeing to universities' control over what they taught, over what they teach. And the challenges that we're seeing right now to democracy in so many ways are so fundamental, and it's absolutely crucial to fight and to stand up for the values that define us as a country. The other point, which I've written about that I also want to highlight, is I recently co-wrote an op-ed in America, which is the Jesuit magazine, specifically about the challenge of religious institutions' commitment to diversity, equity, and inclusion. So for Georgetown, as a Jesuit university, the commitment to what we now call diversity and equity and inclusion is historic and goes back many, many years. So for example, Georgetown in the late 1960s started a Black House. That's what the house was called then and now. Holy Cross started a Black student union. When I started teaching at Fordham in 1991, I was put on a committee that was working on kind of a long-established program during the summer for students of color in preparation for the first-year curriculum. So this is something that I think the administration paints as they're responding just to a recent phenomenon, but for us it's a core commitment and very long-standing. So again, for me, what I'm defending is both the freedom of expression and religious freedom. And this is a moment in which so much is under challenge. Every day when we open the newspapers, I see a new challenge. And it's important to stand up for what we believe in, for what's crucial in our democracy. And what I saw at Georgetown is that people are very supportive in a way that I had not anticipated or thought possible. So, this is a time in which, I can't emphasize, and I repeat again and again, it's very important to stand up for the values of our democracy. So thank you, and I look forward to the conversation.
Professor Kolker. A lot of the 2Ls have class, I believe, at 10:35, so there might be a lot of movement in and out around that time, so just please excuse that and be aware.
So they're not leaving the middle of my talk.
No.
Well, thank you so much for having me. Thank you, Maggie, for all the work that you've done to put this symposium together today. And it's really nice to follow the three fantastic talks that went before me, because I really want to build on a lot of what they had to say, and in some sense I'm also going to be a bridge to this afternoon's presentation on academic freedom, which I was really looking forward to attending, but unfortunately my partner is sick back at the hotel, and I'm going to leave as soon as I'm done talking and drive us back to Columbus. Bad timing on his part. But anyway, so I'm going to be talking about academic freedom specifically in the context of SB1 in Ohio, which a lot of you are familiar with. I teach at Ohio State, and I'm going to talk about Ohio State's over-compliance with SB1, and I'm afraid I may shock you if you're not totally aware of what's going on. But picking up on William Trainor's comments, I've been thinking a lot about resistance, like what does resistance look like in this moment? And so some of what I'm also going to talk about is what I've personally been trying to do as a matter of resistance. And I hope we each can think about what we think our personal role is, because I think being silent, standing back is the one clear path we should not be taking. And, many of us have come to our ancestors came to the United States under perilous conditions, and I often think about that and what would they want me to be doing at this moment in our nation's history. And so, I just think we need to be thinking about what we want to be saying to our grandchildren someday, or great grandchildren maybe in my case, about how we got beyond this moment and what were we particularly doing. So let me talk a little bit about what's going on in Ohio State. So my thesis is that this isn't just a moment when academic freedom is being curtailed. This is a moment when academic freedom is being curtailed in the service of an anti-DEI message. And I think we have to see the linkage between the anti-DEI movement and the restriction in academic freedom. This is not anything close to content-neutral limitations on speech. It's very targeted to a certain kind of speech that's trying to be eliminated. And so in that way, it's nice for me to follow Dean Triener's remarks. So let me just start with an example of what that means at Ohio State, at the law school in particular, because one of my concerns is that this moment is also trying to erase history, rewrite history in ways that are also very damaging. So at the law school, like I'm sure at most law schools, we have this webpage, there's a nice highlight of our graduates and the great work they're doing. So we get this nice little webpage highlighting the work of David Roper. I don't know if any of you know David, but he's a 2019 graduate of the law school. He was the first Black editor-in-chief of the Law Review. He got the university's Diversity Enhancement Award when he was editor-in-chief of the Law Review because he really worked to diversify the Law Review staff in terms of its racial profile. And he also was a really active member of our BALSA chapter. And so there used to be this thing that used to say actually what David did. But then the university came up with what I would call a banned words list. And they said we were no longer allowed to use certain words on our website. And so they then rewrote the website and still mentioned that he got the Diversity Enhancement Award in 2019, but then when they said why he got it, they changed it. And they said that he got it for making the journal, quote, an atmosphere where everyone felt welcome and heard. That's really different than working affirmatively to bring more Black and Latino students onto the law journal. Those are not the same things. And so they've done this repeatedly. A friend of mine runs a program through the law school where they're working to help disadvantaged communities receive better housing resources. A really important thing to be doing. They took a quote from her on the website in which she used the word disadvantaged, and they took off the word disadvantaged because disadvantaged was on their banned word list. And they didn't even go to her and say, is it all right that we're rewriting this quote? And she fought with them, and the quote stands, rewritten, not in her words. I mean, this is really shocking. So I want to talk a little bit about what SB 1 requires and then what the law school itself, the university has done in response to SB 1. And let me just highlight one little bit of it because it also ties a little bit to what Dean Triener just said. So the SB 1 says that a university may not consider, quote, an applicant's political or ideological views in any hiring, promotion, or admissions process or decision. One of the few statements it has on it that I would agree with, okay? That's great. But then it says that each unit has to demonstrate that it is creating intellectual diversity for course approval. Well, how can you do that if you don't know the ideological perspective of the person you've just hired? You can't do both of those things at the same time. And so they're talking on both sides of their mouth because they actually don't mean right that they want intellectual diversity. They mean they want more conservatives. But you're not supposed to, you have to pretend that you're not hiring people because they're conservative, when in fact that's exactly what's happening. And not just at Ohio State, but around the country. Those of us who have friends who would describe themselves as conservative could probably tell you all the schools that are right now approaching them for some really fancy jobs that they never before were being considered for. So that's just happening nationally, not just at Ohio State. Okay, so let me tell you just a little bit about SB 1. Let me keep track of the time here. For those of you who haven't followed SB 1, it does all sorts of things like insist that undergraduate faculty have to post their syllabus on a central website that anybody can look at. That website has to list the professor's qualifications, their contact information, their course schedule. And, this is harassment, right? This is just an opportunity for right-wing people to find out what's in our syllabus and then to try to figure out where our classes are being held to go harass us. And it only applies to other faculty. I feel really fortunate about that, but that's clearly very, very troubling, and we know exactly why they did that. And then they have rules, but we can't have any we can't have any DEI programs. All sorts of programs, of course, have been shuttered. They describe how faculty salaries should be determined, and how student evaluations have to be at least 25% of the evaluation, and that all student evaluation forms have to have the question, does the faculty member create a classroom atmosphere free of political, racial, gender, and religious bias? Whatever that means. And so, my colleagues are really quite concerned. What is this going to mean? What are students going to say? This is anonymous, right? Students can say whatever they want. And then there's a list of what are called controversial beliefs or policies. And faculty and staff must allow and encourage students to reach their own conclusions about all controversial beliefs or policies, and shall not seek to indoctrinate any social, political, or religious point of view. So what's a controversial belief or policy? In case you didn't know, they include issues such as climate change, electoral politics, foreign policy, diversity, equity, and inclusion programs, immigration policy, marriage, or abortion. And therefore, and what does it mean to indoctrinate? I mean, I don't know what that means. Probably every time I open my mouth, I violate all those rules. And then we're not allowed to have diversity statements as part of the hiring process. We can't have orientation programs regarding diversity, equity, inclusion. You're all familiar with that. Okay, that's not well and good, but it gets worse. So Ohio State rushed to implement SB1 even before it went into effect. In June 2025, which is a month before SB1 went into effect, they took down the LGBTQ+ website. Just took it down. They explained the reason they did this is because it violated SB1. But SB1 says that everything has to be open to everybody. And the website didn't require a password. It was open to everybody. It included wellness resources that were open to anybody. But nonetheless, they said they had to just take down the whole website. And then they list on all the websites something like, Ohio State is in the process of revising websites and program materials to accurately reflect compliance with the law. While this work occurs, language preferencing protected class or other activities may still appear in some places, but we're working, into the compliance. And so I'm like, okay, what does this mean? So we happen to have a Department of Women's Gender and Sexuality Studies. That's their title, the Department of Women's Gender and Sexuality Studies. They're having a 50th anniversary celebration. So I wanted to see what could they say who they are. And they do not use the word woman in their description of their 50th anniversary celebration. Like, wow, that's impressive. Whatever. So why would they do this? Well, so the university has come up with terms and phrases with a higher likelihood of non-compliance. And these are words and phrases that anyone running any kind of university website, university system has to take these words off of the website. This is an amazing list. We all should be proud to be on it. It includes diversity, DEI or DEIJ, equity, implicit bias, inclusion, inclusive excellence. That used to be like the catchword, right? Can't do that anymore. Racial justice, social justice, underrepresented, underprivileged, underserved. I mean, there's no way that SFFA requires us to not refer to those terms, right? Because SFA does, so it suggests you should do that instead. Anti-racism. You can't say an event is for, intended to benefit, or especially appropriate for any of the covered categories. You can't say that people in various specific categories are encouraged to attend or apply, or especially encouraged to apply. You can't say that a program or event is intended to increase the number of individuals from a specified protected class or classes. But then they weren't satisfied. That wasn't enough. So then they decided that they needed a policy about pronouns. And so they have a new policy that says that formal options in university business operating systems for community members may not voluntarily notate preferred pronouns. Okay, I know that's like a lot of garbage words, but they're telling us that you can't use any university resource to ask someone to voluntarily disclose their pronoun. And so if you as a faculty member was used to sending a survey to students before the beginning of classes to ask them what pronoun you would like them to use, you could no longer use a university resource to do that. You can't hand out your seating chart and say to students, please indicate your preferred pronoun on the seating chart if you choose, right? Never required. That violates the pronoun policy. Incredible. They decided to ban shocking because they said that it was defacing university property. And any of you who follow Ohio State football know that we hate Michigan, and any M on the university campus is crossed out, is X'd out. Jesse's probably surprised to see how she got for us last year. Yeah, all the M's are like way up high. It would be incredibly expensive to restore all those M's. But they don't care about defacing the M's. They care about chalk on sidewalks that if it would ever rain again, right, would wash away. And then the last thing they did is decided we could not have a land acknowledgement statement on our syllabus. I mean, talk about content specific, right? This content can't be on your syllabus. I don't know quite what the explanation for that is. It's a controversial belief that Ohio State is on the grounds of what used to be Native American territory. I mean, like Miami University of Ohio, they have a land acknowledgement statement on their university webpage, not surprisingly, because the Miami part of Miami University of Ohio is a Native American tribe, right? And so I guess at Ohio State, at least, we don't name them. I mean, as part of our university. So it's bad. So I've been thinking a lot about the pronoun policy because I'm like a real big pronoun person. And you know, I asked about it, got confirmation, and understood that yes, I couldn't do what I'd like to do about pronouns. I could, if I had time, I would talk about the Merriweather versus Hartop case from the Sixth Circuit, which is about pronouns, and would seem to indicate that as a faculty member, I do have choices about what to do about pronouns. And when I write up this for, the law review government legal analysis of the pronoun policy, which I think is blatantly unconstitutional. But I just thought I'd end by sharing with you what I decided to do about this issue. You know, thinking a lot about resistance. Last March, I decided to retire from Ohio State University. I was 69, turning 69 at the time. I was planning to work till my 70th birthday, but I decided to give myself an early birthday present because I didn't feel like I could continue to be involved with admissions and appointments with the horrible policies that were in place, and that I couldn't do anything as a faculty member to resist outcomes that I thought were improper. But I did tell them when I was going to retire that this coming spring I'd like to teach a 2-credit class on academic freedom. That seemed like an appropriate thing to do. And I put together the syllabus, and my faculty, colleagues, of course, approved it. And then this additional stuff came about, the pronoun policy, the land acknowledgement policy. And I started to feel that if I would teach, I would be what I would call collaborating with my oppressor, right? I would be having to either defy them and just get fired, although it's sort of hard to get fired in America, but not permitted to teach class because I wouldn't comply with the rules, or I could challenge the rules, I could comply with the rules, no way, right? So I decided to do something different. So I wrote the following email to the administrative staff at the College of Law, and I then sent a copy to my colleagues. I posted it on Facebook, and all sorts of people have read it, which is so sweet. So I say in my email, as I just explained to Ann, that's our Dean of Students, the Dean who handles the curriculum, I decided not to teach my spring semester class on academic freedom in light of the university's over-compliance with SB 1. I consider it my obligation under Title IX to give students an opportunity to voluntarily disclose their pronouns. I do not want to engage in sexual stereotyping by guessing our pronouns. I also have difficulty accepting that the anti-chalking policy is viewpoint neutral, as the university seems to look the other way at signs meaning to face to cross out the M. The policy against land acknowledgements also seems contrary to First Amendment values. I realize I could stay and fight these rules or seek compromises, but that's not how I wish to devote my energy right now. I'll be traveling to Cleveland on Thursday to speak about academic freedom at the Case Western Law Journal Symposium. That is a better use of my energy. Retirement is wonderful, and I'm trying to take steps that bring me joy. Teaching under the conditions imposed by the university will not bring me joy. I don't plan to be a stranger to law school. I will still come in for faculty coffees and workshops. In fact, in a week or so, I'm going to present this paper to my colleagues at a faculty workshop. Good idea, right? I do have very fond feelings for the board's community, and who knows, maybe I'll teach in the future if the university changes its policies. The best of luck as you try to manage these difficult times. I respect each of you for how you're handling this moment. Respectfully, Ruth. The final irony I'll bring to your attention is on October 3rd or so, I think. I'm going to be getting the first Emeritus Professor Award by the law school, and I will have an opportunity to speak at a ceremony that will, in attendance in the audience will be alumni. I'm trying to figure out what to do with my 5 minutes. I'm thinking of reading the banned word list, reading my email as to why I will continue to teach. So I welcome suggestions from people when they have an opportunity. What's the best way to use those 5 minutes? So that's what I've been thinking about, and I hope each of you are thinking about, is what's the best way for us to use the 5 or 10 or 15 minutes that we find available each day to engage in resistance activity. Thank you.
Thank you for those 4 incredible presentations. Really just covered a lot of ground and very, very interesting. Yeah, I'm not a big sports person. It did take me a while to register what's going on with all the M's being crossed out on all the buildings on campus. Okay, so we have, I think, a bit of time for Q&A. Folks.
Yeah. First of all, Dean Trenner talked about the importance of diversity of thought. Bravo. Which makes me wonder about the composition of the symposium. Obviously, whoever put this together had no concern for diversity of thought. And this is, I think, one reason why higher education has come into such disrepute in the public, and also helps to explain why SB1 was, and measures in several other states have been adopted. This is a symposium about academic freedom. It's all about the measures like SB1 that are being taken now. Nothing about cancel culture. What's that? Nothing about conservative speakers never being invited, and the rare occasions when they were invited, they could be disinvited. If they managed somehow to show up, they'd be shouted down. We don't hear anything about that here. Professor Coker, you're concerned about SB1, one purpose of which is to increase diversity of thought in Ohio universities. And all the panelists are upset that the state is getting involved. Well, these are state institutions, but perhaps, Professor Coker, if people had started to think about, let's look at the faculty. We really don't have diversity of thought on this faculty. We really are one-sided. And, as Dean Trenner said, by the way, I'm glad he said diversity of thought. I don't think there's a heck of a lot of it on Georgetown's faculty. But if people had started to think about that and do something about that, the legislature would never have gotten involved. It's only because measures about academic freedom, that arose only because of cancel culture. The measures for diversity of thought, that arose only because the universities running themselves had decided that they were going to run partisan operations. And I'll also say for Professor James, several things I like to say, but I'll limit to just when you talked about racial hierarchy. You didn't mention that the SSFA case showed that the principal victims of discrimination, racial discrimination at Harvard, were Asians. So I'm trying to figure out here, so the SFFA decision is supposed to maintain a racial domination of America by Asians? What? Wait, what? How is that maintaining racial hierarchy and domination when in fact the principal beneficiaries of the decision are Asians?
Well, I'll let, I guess, whoever wants to go first respond.
I want to, since that was addressed to me specifically, the interesting thing about SFFA was that there was evidence of discrimination against Asians very clearly. The lower court found it, the higher court acknowledged it. There was some confusion or maybe debate about the source of the discrimination, so the lower court thought that this discrimination probably potentially came from manifested like the recommendations that Asian American students were getting from their high school teachers, for example, right? So we can think about what the sources of it are. Could have also been in the screening processes. The idea that these students were somehow getting muted personal index scores, right? And that might be based on discrimination against Asians, which is documented. This is not at all the first time that Asian Americans have been discriminated in the pool. They absolutely are. Okay, but there are empirical questions about where that comes from and the extent to which universities have to account for that. The bizarre thing about the Supreme Court's decision is that there's no remedy for Asian Americans, right? And we know that the only place the Supreme Court has allowed us to use race clearly is when we are remediating discrimination. So it's very interesting that Asian Americans were picked as plaintiffs, right? Sort of used to get the case going forward, because Abigail Fisher is not sympathetic, right? Like middle class white plaintiffs are not sympathetic anymore, but it's like there are advantages here. You can see them, and then you're complaining about a small number of students who got in, and you're making assumptions about what they can do there. So Asian Americans are really used to catapult the case forward, and we acknowledge discrimination, and then the court completely ignores its doctrine about how to fix that. If we think there's discrimination in the pool, and there was, then the solution is more race consciousness. But instead, the court, that's the doctrine, and instead, the court completely ignores that, doesn't really discuss Asian plaintiffs at all, even in the dissent, right? The liberal justices don't focus on this, and we really see that this is actually not about when and where we find discrimination. It's about hostility to the consideration of race, and the court took its opportunity. And so, and I've talked about this at length. I'm not denying discrimination at all, but the court sort of ignores its own precedents about how to address that. But I'll let my co-panelists address some of the other things you said, but I would note that I find it striking that ideas about justice have become so politicized, right? As if the left could have a monopoly on what it means to be just. And if you were discussing things like morality, justice, equality, that must be a project of the left, as if conservatives are not concerned about those things. And we capitulate to that idea in this sort of political polarized space, and it doesn't really make any sense. And I've often said, my conservative students deserve better leadership on that question. They deserve faculty who can come in and engage those questions for them, instead of making it like, if you're discussing justice, it has to be left, right? The right does not discuss justice. It seems bizarre to me. And then the final thing I would say is that baselines really matter here, right? So we think about diversity of thought in faculty, and we can debate whether we think they are or not. I find quite a bit of diversity. Many faculty members I don't agree with, but I respect them as intellectuals on my faculty. But there were not concerns about intellectual diversity in the, dozens and hundreds of years in which faculty were dominated by white men with particular views about how American society should operate. And it is only when we see the inclusion of women and the perspectives they might bring, and the inclusion of working class people and the perspectives they might bring, and the inclusion of people of color and the perspectives that they might bring, that all of a sudden it means we have necessarily skewed to the left, right? And these concerns about diversity
So now you're going to
were
get
not
even.
present before.
Get
And
even.
so it's not about getting even. It's about trying to think about what your unstated assumptions are, that before was neutral, but now has been skewed. when I think people would suggest that maybe before we're skewed, and now we're approaching balance, but if you were a beneficiary of skewed, right now feels imbalanced to you, although it isn't necessarily. I'll stop there.
I'd like to see
Can I
it.
answer?
Yeah, please.
Okay. So, I mean, I think that it's important to recognize two different kinds of viewpoint diversity, and both are important. Both are really essential. One is viewpoint diversity among faculty and among students, at an academic institution. And I do think that, we can do a better job in terms of promoting diversity, but it's something that, that I've been very committed to. So, for example, at Georgetown, about 10 years ago, we started a Center for the Study of the Constitution, which is really about originalism, and it's designed to to create a forum for thought about the original understanding of the Constitution. It's run by Randy Barnett, who's kind of one of our leading faculty and really, a very strong conservative voice. And that's something that I've been very involved in supporting, fundraising for. I'm actually going to be speaking at its symposium next month about one of my books. I think I think one of the things that I think is crucial is about hearing all the voices, and that includes the racial, political, ethnic, in every manner. So I think that's really crucial. One of the things that at last year's, I stepped down as dean, but I said the 2024 orientation to our students is, there are two things I want you to take away from orientation. One is that 13,000 people applied to be in these seats. The fact that you're here means that we picked you because we want to hear your voice. So it's important that you speak and that you say what's on your mind. But I think it's also important to realize that we picked everybody else in this room. We have an entering class of 600, everybody else in this room, because we picked them because we want to hear what they have to say. So the two things I want you to take out of orientation are, it's important to speak and it's important to listen. So, I think, again, viewpoint diversity is absolutely important within a university, within an institution of higher education. I think it's important that we're committed to it, and I think we can do a better job. That's the first point. The second point is, but the government shouldn't be mandating what we teach. The government shouldn't be telling us what we can or can't do. Again, this is, as I said, the case that is kind of the leading case right now for an institution's right to speak is about the NRA. You have the right to speak, across the spectrum. And what we're seeing right now, is that the government is trying to tell us they decide what our academic mission is. And, and I think it's important to fight that. As a leader of higher education, I feel that very strongly. And I also, I have to say that, as a leader of a religious institution, I feel like this is not just an attack on free speech, it's an attack on religious freedom. Because, we have values that are grounded in Jesuit pedagogy, that are based on Catholic social thought. These are values that have defined us. And, what we're seeing right now is, we're being told, no, the government gets to decide what you teach. And that is a violation of basic constitutional principles. So it's important to recognize both points about viewpoint expression.
If I could say just a little bit. When I think about the current moment and what's happening, I do think of it as a response to the success, to some modest extent, of diversity in my lifetime. When I started teaching in 1985, most of the schools that interviewed me, I would have been the second woman on their faculty. Second. Sometimes the first, but usually the second. I joined the faculty where I'd be the third. because I didn't want to be the first or the second. When I was in law school at Harvard, 25% of my class was female. In law school now, as I'm around the country, more than half the students are women. There's been a lot of changes, but no faculty that I've been a part of is close to 50% women. And I remember when I was in high school, a teacher at my white suburban high school asked if we thought we were in an integrated public school. And a student raised his hand and said, yeah, because we have so-and-so and so-and-so and so-and-so. There were 800 students in my graduating class. And the teacher quite smartly said, if you can name them, you're not integrated. Well, I can name the black students in my law school class because we were not integrated. Most people knew the names of the women because we were such a distinct minority. And so we made a lot of strides. We're here on this panel. And so it's not surprising to me that we're seeing a backlash. And I think that's what we should call it. And they can disguise it as an interest in intellectual diversity, but that's not how I experience it. I experience it as an attempt to close the door that has started to open. Reason people can disagree about that, but that's my perspective. And as to whether we're fair to our students, in my 28 years of teaching, I not one time had a student on my SETs, my student evaluations, say that I was not promoting intellectual diversity in my classroom because I go out of my way to expose my students to a wide range of views. It would make no sense for me not to teach the conservatives on the Supreme Court because they are the ones in power. Of course I teach that material, and I teach it for what it is and what it says, and I try to expose it, its rawness, the full length of everything that is said. I've had students ask me how I can do it. I mean, it's hard sometimes, but I feel a responsibility to do that. So I think that someone who hasn't been in our classroom and hasn't seen how we engage our students really has no right, in some sense, to comment on whether our classroom promotes intellectual diversity. I think the people who can say whether that's the case are the people who are sitting in that classroom. And one fun little anecdote, there's a lot of discussion about whether common law, should be taught by some really conservative professors. It's not fair to only have us people who don't believe in originalism teaching it, although of course I teach originalism. I have to. So this academic year at Ohio State, we have 3 seconds of common law. 2 of them are taught by people who I think would be comfortable being described as progressives. One person would be someone who would be totally comfortable describing himself as a conservative who believes in originalism. The students enrolled. We have 73 students in Section 1, 75 students in Section 2, and 16 in Section 3. Guess who is teaching Section 3? The conservative faculty member. So the students voted with their feet as to which faculty member's class they wanted to take. So I actually don't even think that it's fair to say that the students feel that they've been mistreated and not had the opportunity to have faculty member who identify with originalism, identify with conservative viewpoints. But anyway, I don't want to dominate.
I'd like to just say a couple of thoughts. So when we assume that there's no diversity of thought, it's interesting because I don't know how you know that about.
There's a good column in the Wall Street Journal last week about the partisan tilt of
they weren't
faculties.
writing about me or my panelists or Dean Traynor, and I'll tell you something that happened when I taught Con Law 2 in Idaho, and I've taught at several faculties where I wish you could be sitting next to me and ask me about my experience there. But in any event, one of my evals from Con Law 2 said something like, injects personal beliefs about abortion and has no care for the sanctity of unborn life. And I sat through a meeting with the then interim dean about my behavior in that class. And I said, and he said, what do you have to say? And I said, well, I'm a practicing Catholic. And my personal beliefs, but not the way I teach or indoctrinate my students are actually have been so well disguised that I was misread in the other direction. And then to the extent that I have, of course I do have liberal leanings, what I fear is that I overcorrect so much to avoid the kind of criticism that we're hearing today, because it can be career ending, especially when evaluations have that much power. So having existed in spaces both as a lawyer and a law professor, where I'm usually the only person representing the particular identity that I'm writing about once I transitioned into disability, and having to really I have to answer questions that people who are not disabled and saying more radical things than me don't have to confront. I'll give you an example. I need an accommodation myself at my workplace. I've been asked things like, I've read your scholarship, are you asking for what the law requires or the radical arguments you've made in your law review articles? I don't think people that don't have my identity and happen to also write about it face the same thing. So I love the reminder from Professor James about what's our baseline and what's our perception. I've existed in spaces where I've felt philosophically, ideologically lonely, and it's funny, in Simpro spaces I've been called quite conservative and I've had blog posts written about me. That struck me as odd, but I've had different labels, and maybe I'm just an enigma. But I will say that when it comes to ideology and politics, as a person that belongs to privileged groups and non-privileged groups, I can read a room or the workplace I'm in based on how things like civil rights law are intermediated in personal relationships. And in legal academia is the most politically and socially conservative space I've ever existed in, to my surprise. And sir, I'm telling you my experience and you're rolling your eyes. So why can't we have an exchange about this, or why is my
I'd love to. I would say, I know others have to have a turn, but I'm very sorry that whoever organized this did not include on the panel someone who would present opposing
I gave you
views.
an example of some of my conservative viewpoints and the fact that I actually am an outlier in my area of the law.
That may well be so. Again, this recent column in the Wall Street Journal, just as an example, cited several surveys of faculties showing where their ideological views lie.
Those surveys are so easy to answer, and I do think that there are colleagues that I work with who will vote Democrat, like the character in Get Out who said, I would vote for Obama again. This is what those surveys sometimes represent. Thank you for those of you who got what I was saying. It doesn't mean that you actually live and believe that civil rights and anti-discrimination matters. If you are problematic in the ways that those laws are intended to save us all from, in the way you interact with the person in front of you or the person that you're hiring or your students, you are not ideologically liberal. And those are the interactions that I care about, because it's how our students experience their education, it's how I experience this room, it's how you experience this room, right? It can't be foretold by a survey printed in the Wall Street Journal. We're smarter than that. You are, sir.
I want to see if anybody else has a question or would like to jump in. Yes, go ahead in the back.
So, I know that when it comes to politics, the pendulum sort of swings back and forth. So let's say that the next administration comes in and adopts a pro-DEI position. So they come into office, and a lot of the sort of issues that we've talked about today, do you think that it would be enough for that administration to simply walk back all of the policies of the current administration to effectuate the what we would consider to be a pro-DEI position, or do you think that some additional steps would be necessary in that scenario? And if so, what would those steps be?
I think that's a great question. And what I see is some of the significant shifts now is not just new policy, I added this, I eliminated that, but a real shifting of norms. It's not clear to me that just because you get a different president, those norms are completely reinstated. And a way of doing things, right? How do we respond to lower courts? How do we engage universities? To what extent do we feel like we can control universities? Those are fundamental American norms that are being shifted, and it's not clear to me that just because you get a Democratic president, right, our sense of how we engage these issues automatically shifts back. And the ways you get people invested in democracy is they feel like if I do the right things and I play by the rules, there was some benefit to it for me. But if you have years of people breaking rules or breaking norms and winning by doing that, you know, a political position is not going to snap everyone back to the norm. Instead, you do what benefits you. And I would never presume that, a Democratic presidency would not have expression, intellectual.
I'll speak more specifically to issues related to disability and the presence of students with disabilities in education. So the early laws granting a free, appropriate public education to students with disabilities came about in the 1970s. So let's say it took maybe 20 years to get those students in college. Right now, I talked about higher ed, but the shuttering of Office for Civil Rights Enforcement offices across the country, so 7 of 12, means that all of the enforcement efforts that were keeping kids with disabilities in schools and getting them services through their IEPs and Section 504 plans, really just all these efforts that over the course of decades put kids who literally had to stay at home and had no education or were segregated in seats and on the path to go to college. That retrenchment, the loss of those services, is going to have a multi-generational effect. I suspect we'll see the numbers of students with disabilities drop in higher ed as the impact of the loss of services that they're experiencing now trickles up into those spaces. So we know how long it took to get those kids into higher ed. I think it's going to take time to just get them back on track, and there will be decreases in their representation for more than the duration of a presidential term.
I think it's also important to recognize, you're focusing in on specific rules. One of the things that this administration is using is really kind of really a coercive approach that's new. So kind of under previous administrations, Republican and Democratic, when the education department had issues with an institution, there was a back and forth and there was a process, and at the end there was a resolution. But it was a process. What we're seeing now, and I think it's just, it's so harmful in every way. And I think, that a future Democratic administration cannot do this, is do what, for example, we're seeing with Harvard, which is kind of all of their funding is being cut off up front in order to coerce results. So I think, as we're focusing in on the specific rules, I think it's also important to look at the process and the procedures. And what we're seeing now is really a lack of process and procedures that really is coercion. And, that regardless of whether the rules are right or wrong, that cannot go forward. That, because that is, again, just government mandating what's taught without even going through any process to find out what's actually happening.
Let me just say one little thing. What I often say to people is, I don't see this as a moment. I think this is a transformational age. So obviously I'll care about who's the president in 4 years, as I always do, but I think that in some sense it almost doesn't matter. So transformational. And it isn't just the anti-DEI stuff, it's the anti-intellectual nature of what's going on in higher education generally. More online courses, less in-class instruction, more emphasis on AI. So I think there's a lot of different things happening at the same time, but I think that the constellation of them all is to really dramatically change what higher education means.
Can you speak louder?
Okay, sorry. I'll speak closer to the mic. Anyway, I see this as a transformational era, and I think that's what I think of it in terms of resistance and what can we do. But I think waiting for the next election that's going to solve problems, I think is pretty naive. And so I think each person has to decide for themselves what can they do at the ground level. But I think higher education has been transformed in a way that's probably irretrievable for so many different reasons. Mister.
I think I said, yeah, Daniel.
First off, thank you for being here. I think that in recent executive orders, we've seen that DEI and affirmative action has been seen more on the right as almost synonyms, or in other words, affirmative action, DEI coming under the umbrella of affirmative action. I'm curious, do you think that these two ideas are distinct, and if so, what are those key distinctions that you can point to?
I'd like to say one little thing about that. As Kat knows, I'm writing a piece about what the meaning of the A is in DEIA. I was thinking of next writing a piece on the meaning of the I in DEI. I mean, I think that it would be good for us to separate these concepts and not to just lump them all together. And SB1 does that, just can't do DEI. But then when I was listening to our President Carter's State of the whatever Ohio address he gave, his university president, he actually used the word inclusion. And I was like, oh, but that's on your list of banned words. But I actually mean that sort of seriously. Like, maybe there's going to be some pivoting back to what the word inclusion means, and maybe there'll be some way we can come together about what the word inclusion means. I can't understand why you'd be against inclusion. It seems like fundamental, but it's on our banned words list.
Your question really gets to how language is used and what it's meant to symbolize or signal, right? Whose ears perk up when you use particular words. These are strategic decisions about what we're going to call things, what we're going to lump people together, how we're going to lump programs together. It's interesting to think about DEI and like law school curriculums. If you're not allowed to talk about race, you're not allowed to talk about gender, you can't talk about class, and you can't talk about law. Right, and so it's like, is there any DEI in the first year curriculum? Well, are we talking about laws that impact people in different ways? Are we thinking about rape shield laws? Are we talking about I can't teach civil rights? I can't teach Title VII, right? Equal protection is about race, and so these words they're not precise. They are meant to signal something, and they can be used in different ways. That's a DEI hire. What does that mean? That means everyone look, a person of color or a woman got a job, right? That's not a good thing. It's not actually meant to signal anything about that person's actual qualifications. And so, getting into like what does it mean or is it separate is actually not the point. I think the point is, what are we signaling in the air, and how do we want people to galvanize in response by using these phrases that actually don't mean anything?
I did some research this summer about affirmative action in the context of disability, and then went pretty deep into history and looking at the origins in New Deal administrations and the work of economist Robert Weaver. And the further along historically you get, at least as Professor James was saying, the use of the terms as insult, I think, is absolutely similar. As someone who has some memory of the 90s, it feels familiar. So in this paper that I wrote over the summer, I found some great quotes from the mayor of Baltimore, Mayor Brandon Scott. So when the Francis Scott Key Bridge tragically collapsed in Baltimore, I think this was about a year and a half ago, he was labeled a DEI mayor and accused of somehow being responsible for the collapse of the bridge. And I love the way he responded. He said, when they call me a DEI mayor, we know what they want to say. And the replacement word is a racial slur, right? And I think it can, depending on the context, I think in this context, it gets close. It absolutely is standing in for a word that is socially unacceptable to say, but the vitriol and the venom remains.
Sorry, I just had another follow-up. I've always been really particular about how we think about admissions, right? And what does the word affirmative action mean? What meaning has it taken on? I prefer race-conscious admission, which is more specific about what is happening. And so again, just to emphasize your point, it's a great question that the language we use matters, and it carries much more than just like the technicalities of the words used.
And I think it's, again, I think it's a very good question. DEI, goes beyond affirmative action. And I think race consciousness is the right way to put, what's happening, the approach to admissions. I think it's the right approach in admissions. But, when I talk about, DEI at Georgetown, it's really about kind of empowering all the voices and, helping, encouraging people to talk and to feel comfortable talking. And sometimes race consciousness is part of that, but it's also kind of bringing people together. We have an interfaith advisory group that has students from all different religions. And I have to say, in the wake of October 7th, that was very important for us. That the Jewish and the Muslim law students were talking together. So again, I think affirmative action is part of making sure that all the voices are present in the room. But DEI, is about making sure that the voices are heard.
Yeah. So thanks for this. This is a really interesting panel. And there are a lot of strands. I want to pull on one that maybe people haven't talked a lot about in the discussion, which is a lot of the motivation, or at least the opportunity for state actors to exercise power here, comes from the fact that higher education institutions in America are so dependent on public funds, which is, in my view, very much a good thing that higher education institutions are very dependent on public funds. We have generated enormous amounts of knowledge that benefits our students, our faculty, and the world because of it. But there is, something that's resonant to people of a lot of different political persuasions that, well, if we're paying for this, then we ought to have a say in the content of this. And so if we're looking to like a new settlement after what's going on right now, what's the way to think about how we maintain institutional autonomy, maintain academic freedom, maintain academic institutions as independent civil society, knowledge-generating institutions that aren't controlled by the state, recognizing that they need to be funded significantly by the state? Like, how do we get to a world where we do that, both institutionally and politically?
Question. Who wants to tackle it? Who's got the answers?
Well, I guess I might distinguish between the money that institutions get from the federal government and the money that institutions get from the state government. So when I think about Ohio State as a supposed land-grant institution, which is sort of funny because the land was granted to us from, tribes who held it, but whatever. You teach at Michigan, which is obviously a state university as well. I mean, the idea that Michigan and Ohio should fund higher education because it's really good for the citizens of Ohio and Michigan seems to me to be really basic. But I also think that we have to think about the way admissions has become very exclusive. I know Ohio State's been working on letting people transfer automatically from two-year community colleges to Ohio State to get a four-year degree. I think that's a great thing to be doing. I just read that they're even going to say that the tuition for those last 2 years might be free, that the state might pay for it. So I do think we should have more of a conversation about how to make higher education more accessible to everyone. And obviously in Ohio, that includes people from Appalachia, which I know Ohio State has always cared a lot about. Those people tend to be white. So I think at the state level, if we could do a better job of making education more accessible to literally everyone, of course that includes our students with disabilities as well, I think that would be a good move. And I think in some ways, this move towards elitism, selectivity, is contrary to that. Obviously, I'm sure Michigan's a lot harder to get into than Ohio State, but even Ohio State, I hear criticisms from alumni that how their children couldn't get in because admissions has become so selective at the undergraduate level. So I think that's a little different than the federal government's role. And you've worked for the feds more recently than I have. I haven't been working for the federal government since 1985, but I think that's a lot more complicated because that money isn't really going necessarily to universities as universities. It's going to medical centers and research institutions, and it's not really going to the university because of his role in teaching. It's going to the university because of his role in research. So I guess I think there's a different constellation of reasons for why we would do that. But I do think that one of the things we're seeing in the current moment, which seems contrary to prior constitutional law, is that they're taking a supposed concern about anti-Semitism, which of course I don't accept that that's the concern at all, but they take the supposed concern about anti-Semitism and then they say that Harvard can't have any of its federal research dollars to cure cancer or whatever else. And there used to be Supreme Court precedent about not using funding threats in that coercive way, and I'll be curious to see if we get some more case law on that. So I guess I would just distinguish between the state funding and the federal funding. I'm not sure it's the same constellation of interests in issues in both contexts, for however helpful that might be.
That's a great question. So how do we reconceptualize this if we had to do it again? I want to push back. I don't think this is what you were suggesting at all, but push back on the idea that because you pay something, you pay for it, you're like owed something in person. It's a very consumer model of education, which I want to push back on. But assuming we accept the idea that if I pay for it, I get something, then the question is, what am I getting, right? What am I paying to get? And I think, citizens of the state who are paying for higher ed, you're not paying to see your views necessarily reflected back to you. You're not paying to get a particular outcome that makes you feel good. What you're paying for, though, is maybe the obligation of the state to serve its citizens through its work, right? What is our mission? Do students have access to the resources we're developing, the knowledge creation that's happening? How does it serve the state? Like Carolina should be serving citizens of the state. How does the research, how does the teaching, how does the knowledge production enhance our lives? My life, I might disagree with what a faculty member is saying, but what I paid for was an opportunity for a student to become a lawyer, right? To learn how to do that and to go out and serve people in our justice system, even if my particular ideologies are not reflected back to me. And so just thinking about how we think about what do you pay for? What are you paying for when you support a state institution? And I think it's more about the institution's obligations to you and less about getting to dictate what the institution is doing or getting to dictate that it gives you something that you want to see that makes you comfortable.
So I think my greatest familiarity is with the federal system. And I think the federal government should not be in the business of promoting ideology at all. What we have right now is two things, there are two sources of primary, federal funds. One is it funds scientific research, and the other is, student loans. And, I think those are both very important. What we're seeing right now is that, the current administration is using those sources of revenue really to kind of coerce, changes in, what's taught. And, I think it's important to think about, are there things that can be done, with respect to kind of, making sure that, all voices are heard and, that there's a range of ideologies that are expressed in school. But that's not the role of the federal government. And, that's a huge concern that we're seeing right now is kind of a monolithic federal government is using its great power, to coerce what's taught.
It's interesting. I've had experiences at state schools, and I'm at a private institution right now, and faculty members were recently suspended, as far as I understand, following calls made by state politicians to the chancellor to complain about some of their recent social media posts. Obviously, that's too much, right? But when I worked at Idaho, there was an understanding that the dean of the law school had to have a personal relationship with either the governor or someone in the legislature, in part because funding was, at their discretion. It also meant that tenure committees had someone, there was a representative that somehow represented the state that would sit in and get to vote and write about your scholarship and your teaching and, you know, who you were. It was uncomfortable in my case, because I wrote quite critically about the judiciary, and it happened to be a state judge who was, you know, not pleased with the way I had written. But that's a little bit closer, I think, to some sort of meaningful participation. I actually like the problem is like if someone says we need independence, who is competent enough to ensure that the state voice can look at how I teach or what I write and determine if it is fair. Maybe teaching is a little bit better way to think about that. And competency is a big issue, and I think the debates about critical race theory really illustrate this, because none of the attacks on it, it's like, what are you talking about? Like, this exists in such a small area of academia, and not in the way that it's being described. It doesn't exist in, you know, elementary school libraries. So where's the expertise? Where's the competency? How can we bring people to the table while respecting not just intellectual independence, but the way that we have been determined to be qualified to teach and to write? How can I engage in conversation with someone that I want to, but how can we ever be talking about the same thing is what I worry about right now. I think it should be possible, it could be possible. I haven't had an opportunity for it yet in the various institutions I've worked at.
Thank you. Please join me in thanking our panelists for a great discussion.